So I want to talk to you for a few minutes about the topic of the federal court system, about how it's structured, and also how judges get their jobs. So as you probably know from the reading, most court cases are actually decided in state courts in the United States, but our focus here is on the federal courts because this is a class in American government, and the federal courts deal with major constitutional issues as well as federal laws. So there are three basic levels to the federal court system. The lowest level of the court system in the United States would be federal district courts. There are federal district courts all over the country, some 94 of them. Each state has at least one, and usually more than one. In Michigan, there are two federal district courts. We're divided east and west. The Eastern District, which is where we live in southeast Michigan, that court is based in Detroit. It's the federal district court for the Eastern District of Michigan. And it handles trials in this part of Michigan, federal trials. So if a case involves a U.S. law or it involves the U.S. Constitution and it arises from anywhere in this part of Michigan, it will go to the federal district court in downtown Detroit. Okay, so that is its jurisdiction. Now, in terms of what it does is it decides if it's a criminal case, if someone's charged with violating a federal law, then the court's job is to decide whether he or she is guilty or not guilty of the crime. And there will be a jury, and that jury is made up of average citizens from the eastern part of the state of Michigan. So that is the federal district court. Now, they also deal with issues of law in this area, as well as civil liberties and civil rights, and a number of other constitutional issues. So anything that arises out of this part of Michigan that deals with the U.S. Constitution or federal laws will go to the district court in Detroit. That is separate, by the way, from the state courts in Detroit. So, for example, a lot of people are familiar with the Frank Murphy Hall of Justice and the 36th District Court. That is not part of the federal court system. Those are state courts that deal with state issues and are not the subject of what we're talking about here. So we're talking specifically about the federal district court in Detroit or anywhere somebody might live. So if you lived in Grand Rapids, then the federal district court would be for the Western District of Michigan. If you lived if a case came out of Ohio, it would be out of one of the district courts there. So the trial court's job is to decide the facts, decide guilt or innocence, or guilt or not guilty if it's a criminal case, and then a jury reaches a verdict. From there, if a person wants to appeal, particularly if it's a criminal case and someone's been found guilty and they have the right to appeal, they take it to what's called the Circuit Court of Appeals. There are essentially 13 circuit courts in the United States. So obviously for a nation of 50 states, that means each circuit includes more than one state. We in Michigan are located in the what's called the Sixth Circuit. The Sixth Circuit is headquartered in Cincinnati, Ohio. So all federal appeals from Michigan, Ohio, Kentucky, and Tennessee go to the Sixth Circuit Court of Appeals in Cincinnati, Ohio. And again, that would only be for appeals, not for the original trial. So if the trial would start out in the local district court, the federal district court for that part of the state, in our case, it would be the one in Detroit, and then the appeal would go to Cincinnati. The job of the Circuit Court of Appeals is to decide the legal issues in the case. Their job is not to decide whether someone is guilty or not guilty. Their job is to look at the law, the legal issues, and decide whether the lower court, the federal district court, made a mistake in the way it dealt with the law. It can reverse a lower court or it can affirm a lower court. And then the judges issue their decision in a written opinion, which explains what the reasoning was in the decision. They decide by a majority. Generally, it's a panel of 3 judges. Sometimes it's more. It's never fewer than 3. It's always going to be at least 3, and it does take a majority to decide the case. After that, if someone wants to take a case higher, they could potentially take it to the U.S. Supreme Court, which is the highest level in our court system. However, the U.S. Supreme Court does not take very many cases. As you'll read in Chapter 12, they go through a process of reviewing lower court decisions to decide which ones they want to take. That's called the certiorari process. The losing side in the Court of Appeals would take their case to, or send their rationale to the Supreme Court as a petition for certiorari, and then the Supreme Court justices look at those petitions and decide which ones they're going to look at as a full review. They operate on the principle of the rule of four, which means at least 4 of the 9 justices must agree to take a case. If fewer than 4 want to take it, they will not take it. 4 is obviously not a majority, but it's enough just to grant review or grant certiorari, which is also sometimes called granting cert, C-E-R-T. There are 9 justices on the U.S. Supreme Court. In a given year, there are probably about 7,000 petitions for certiorari filed with the Supreme Court, and they typically agree to hear about 70 of those petitions, which means that they reject pretty much 99% of all the cases that come to them and only take about 1% of the cases for full review. Now, when they deny certiorari, they're not saying that they agree with the lower court decision. They're not saying they disagree with it. They just don't have 4 justices who want to look at that issue. And that's for good reason in most cases, because the court has already established the meaning of the law, whether it's civil liberties, civil rights, powers of government in the Constitution, and many other issues. They've established it. So if there are 4 justices who want to take the case, that means that they might be considering a review and possibly changing the law or coming up with a new interpretation of the Constitution in some area. So the 3 levels again of the federal court system would be the federal district court, which is the trial court in our system, and again each state has at least 1 district. Most states have more than 1. We have 2 in Michigan, Eastern and Western. Then you have the Federal Circuit Court of Appeals, whose job is to hear appeals only. They do not try cases. They only deal with appeals. And then finally, the U.S. Supreme Court, which only hears, as I said, about 70 cases a year. Now, that people say, well, that means they don't have a lot of work to do. The reality is it does take all year to hear those 70 cases, because it's not just, the case comes before them as an oral argument where they ask questions of the lawyers, which takes about an hour. But before that, they have to read through briefs that are filed by the parties in the case, as well as outside groups. So they have a lot of things to consider. And then after the case has been heard, they have a conference to discuss it and then vote on whether to affirm or reverse the lower court. And then the majority side writes the opinion. They explain the reasoning behind their decision. And that could take several months, many months in really complicated cases. And then those who dissent from that opinion write their own opinions, which are not legally binding, but they are important. So make sure you read through that in the book, the process of certiorari and how the Supreme Court reviews cases. The other issue I wanted to talk about is the appointment process for federal judges. Again, all federal judges, whether they serve on the U.S. Supreme Court, on the Supreme Court they're known as justices, not judges. There are 9 of them. That number 9 is set in law. It could change, but it currently is set at 9. There are 9 justices, again, lifetime appointments. So once they are seated on the court, they serve as long as they want to serve. The president appoints all Supreme Court justices, and then they have to be confirmed by the U.S. Senate by a majority vote. And then once they're confirmed, the justice serves for life. Now that applies not just to the U.S. Supreme Court, but also the lower level federal judges. So federal district court judges and federal court of appeals judges also are appointed by the president, confirmed by the Senate, and they serve for life. So that whole idea applies to all 3 levels of the federal court system. Now there's a lot of attention paid because, particularly with the U.S. Supreme Court, that's the highest court in the country. It has the most significance in terms of our Constitution. And a president can appoint someone to the Supreme Court, and that justice is going to serve long after that president has left office. For example, the most senior justice right now in terms of length of service has been there for 30 years. So the idea is that when a president appoints somebody, particularly if they're in their late 40s or early 50s, they're likely to be there long after that president has passed away, and certainly long after they've left office. So it is an important part of a president's legacy, but it also applies to lower level federal courts because most cases don't actually get to the Supreme Court. So there's a lot of significance in presidential appointments, not just to the Supreme Court, Most presidents get at least one or two, and sometimes as many as three appointments. But more of their appointments are going to be at the lower levels. And again, that's where most cases are finished, because they never actually make it to the U.S. Supreme Court. So the process of appointing judges and federal Supreme Court justices has gotten to be very political. It used to be a lot less so, because presidents were more focused on who made the most sense in terms of the law. Obviously, a Republican appointed judge or justice might be a little more conservative. A Democratically appointed one might be a little bit more liberal. But generally, they were more middle of the road, and there wasn't a huge controversy over the nominations. Sometimes there was, but most of the time there wasn't. But in the last 30 to 40 years, these judicial appointments have become extremely political and very polarizing. So a lot of times, Supreme Court justices will wait until a president of the same party that appointed them is in office again. And there used to be, again, there have been times, not many times, but there have been a few times in our history where the Senate has refused to confirm someone. They voted somebody down, which is their right to do. In 2016, there was a vacancy on the Supreme Court when Justice Antonin Scalia died. He had been on the court for about 30 years. He died. He was a very conservative justice. He had been appointed by Ronald Reagan originally, a Republican. He died. President Obama was in office at that point. This was in February of 2016. 2016 was a presidential election year. The election, of course, is in November. So when when the vacancy came up, President Obama still actually had 11 months in office, because new presidents take office in January. So he did make an appointment. He appointed a judge by the name of Merrick Garland to fill that vacancy. But the Republican-controlled Senate said they would not act on that nomination. Their opinion was that we were having an election that year, and that whoever was elected president in November of that year should be the one to make the appointment, not the current president. Now, of course, again, presidents have a 4-year term of office, and at that point, President Obama still had almost a full year left in his term. But the Senate did refuse to consider the nomination, and so there were no hearings, there was no vote, and then in November of 2016, Donald Trump was elected president. Republicans kept their majority in the Senate, and so a few months later, when President Trump came into office, he made an appointment of Neil Gorsuch to that seat, and the Senate very quickly confirmed Neil Gorsuch to the seat, again, a lifetime appointment. More recently, just about 6 weeks before Election Day in 2020, Justice Ruth Bader Ginsburg died. She had been on the court since the early 90s. She was appointed by a Democratic President, Bill Clinton, and so she died while still serving in the court. She was considered to be a liberal justice. And of course, 6 weeks to go before Election Day, and some people were voting early already. Democrats argued that since Republicans 4 years earlier had said that President Obama should not be able to have an appointment 11 months before his term ended, then President Trump should not have one just a couple months before his term ended. But the Republicans still controlled the Senate, and so President Trump did appoint Amy Coney Barrett to fill that vacancy created by Justice Ginsburg's death. And very quickly, the Republican Senate did confirm her, and now she serves on the Supreme Court for life. She's a very young woman. She's in her late 40s, appointed in her late 40s, and will serve probably for at least 30 years on the court. So the question is, was it right for the Senate in 2016 not to consider President Obama's appointment? Obviously, Republican Senate was not necessarily going to be supportive of somebody that Barack Obama was appointing. On the other hand, the man that President Obama appointed was qualified for the court. He had been a federal judge for a number of years, and certainly had all the credentials for a Supreme Court justice. And some people argued that they could have at least considered the appointment, and they still had the right to vote him down. But they decided not to hold any hearings or even consider the appointment. And of course, they waited until President Trump was elected. Now, of course, Hillary Clinton could have been elected in that election, and then we're not sure what the Senate might have done with that. But the bottom line is, it's become very, very political, and it was not always like that. There were certainly times in the past where even the opposing party, if it controlled the Senate, would still confirm a president's appointment to the Supreme Court as long as they weren't unqualified or as long as they weren't too extreme. But these days, it's gotten to a point really where you essentially, if you want to get a justice through in terms of an appointment, hopefully your party controls the Senate, because otherwise you're going to have a hard time doing that, which is something that President Biden will face in his term in office. So, and that also applies to the lower levels of the federal judiciary, because again, that's where most cases stop. They don't actually get to the Supreme Court as much, and so the lower court decisions actually have a lot of significance, and presidents can have a lot of impact there in terms of their appointments, and so those have also become very political. So, any rate, so that's kind of the judicial appointment process. There's also a discussion of senatorial courtesy in Chapter 12 and some other issues related to appointments to the court. So please make sure you read through that and contact me with any questions. All right, have a great week.